Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
Hello, ladies and gentlemen. I welcome you to yet another interesting edition of Law Simplified with Justice. I remain your regular host, Justice Maduforo. As you know, this program brings the very best of legal topics ranging from criminal law to immigration law to employment law and to contract law. Over the years, I've brought in very interesting topics, and most people have been tremendously blessed with the topics we discuss on here. Today is not an exception to those days. I'm bringing in a very interesting topic. As a matter of fact, this topic is very dear to me. It is dear to me because in the course of my practice, I've seen that catastrophic errors upon catastrophic errors as people go along the way when it comes to the employment. Today on this show, I'll be discussing disciplinary procedures under the employment law. Ladies and gentlemen, I repeat again, I'll be discussing today disciplinary procedures under the employment law. Now, it's important that I bring this topic because I literally walked out from the employment tribunal today with heartbroken in respect to such situations I saw or the particular case I dealt with. The reason being that a lot of issues ought to be harmonized before a claim is lodged. Obviously, as a matter of fact, harmonize the claim or at least identify a claim. Now, ladies and gentlemen, before I go into this, as usual, I will always tell you that whatever I do say on this program or my guest on this program is purely our opinion. You must not and should not act on them, but rather seek independent and well-tailored advice, legal advice, before you can act on them. I repeat, do not act on whatever I say on this program. It is merely my opinion. As a matter of fact, you must seek legal advice before you can act. My telephone number is on the screen. My email address is on the screen. If you do wish me to advise you, then we have to book and arrange an appointment for you to come to the office to see me. And I will take detailed instructions from you and advise you the way it suits your case. As a matter of fact, from there onwards, you can now act on what I advise you. Ladies and gentlemen, as I did say from the beginning of this program, I'll be discussing employment law. And the topic is disciplinary procedures under the employment law. Over the years, the legislation has come up to protect employees. Not just employees, those who are self-employed, those who are volunteer. Now, this is enshrined under the Employment Rights Act of 1996. That legislation gives your right, spelled your right as it is. However, where there are issues of disciplinary issues, where there are issues of conduct, where there are issues relating to gross misconduct on the part of the employee, on the part of the self-employed, on the part of the volunteer, on the part of even a part-time employee or full-time employee, regardless. Now, once there is a conduct issue of which your employer, therefore, now wants to investigate, that is where this topic comes in, and that is called disciplinary procedures. Disciplinary procedures are provided by the Employment Act of 2002. That spells out the minimum statutory procedure that the employer must follow. I repeat again, these are minimum statutory procedure that you as an employer must follow, regardless and irrespective of the size, shape, or number of that organization. Be it an organization that employs one person, two people, 10 people, even dozens and scores of people. Regardless of that, as long as you are an employer, this law catches up with you. And this procedure you must follow. Now, these procedures are set out in Schedule 2 of the Employment Act 2002, What does it state there? It clearly states the steps that ought to be taken before an employee who is alleged to have committed a gross misconduct or misconduct, before he is or she or he is terminated or dismissed of his employment. Now, this is very important. However, for the purpose of this discussion today, I'm going to be dealing with prior to that disciplinary meeting taking place, prior to and during the disciplinary meeting. Now, let me come down to give you another instance of why you should and must make sure that you harmonize what you want to say during that meeting. That meeting is very essential. That is a meeting that can make you or break you as a result of that. Now, that meeting can either deal with issues of claim in the future, present claim against your employer, or no claim whatsoever. That meeting could actually deal with your admissions in respect to the allegation against you, you admitting it without you knowing. This is the very painful part of it. I've dealt with these matters and it pains me. And that's why I'm bringing this to the wider community. You should not and must not take steps that will adversely affect you. As I said, do not take steps that adversely affect you, because this is very important. As I said today, I'm bringing this topic with really a great interest to me, because most of the employment cases I've dealt with have been summed up on the fact from the beginning of this case, meaning from the moment disciplinary procedures have commenced. These are disciplinary procedures that had to be dealt with before employee is dismissed. Sometimes the employee dismisses himself, terminates the contract, or walks away from the employment. Why? This is where it comes, what is termed as constructive dismissal, as a result of a fundamental breach of the contract under the Employment Act, Employment Rights Act, and Employment Act 2002 and 1996. This is where the employee can walk out, literally walk out, even contrary to the contract. It's only when the employer has breached a fundamental aspect of the contract of employment, be it oral or written. Once that takes place, the employee can walk out and bring an action, what is called constructive dismissal. However, I'm not dealing with that. I'm dealing with the procedures, what you as an employee, you as a self-employed, you as a volunteer ought to do prior to the disciplinary hearing. Now, the law has provided that disciplinary hearings ought to be followed, investigated. As a matter of fact, the investigation takes its course, and before the employer should be able to know and ascertain whether there is a case against you, the employee. Once the case is ascertained, then your employer can take the next step, and that may lead to dismissal, or that lead to formal warning sometimes. If in cases of gross misconduct, it's automatic dismissal. Now, this provision of the law under the minimum statutory right disciplinary procedures that ought to be followed by each employee, as I said, irrespective of size and number. It must be followed. The moment, I repeat, the moment the employer fails to follow these minimum statutory guidance and procedures and dismisses you as an employee, self-employed with an organization or a volunteer, that automatically the tribunal, the employment tribunal, will see it as what is called automatically unfair dismissal. And then that is where it kicks in. So this topic is actually for you employee, even for you employer. What are the steps you need to do to safeguard you opening yourself up to potential claim in the future in the employment tribunal?
Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the individual rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.